Good afternoon. I'm Leonard Baines, Dean of the University of Houston Law Center. I want to welcome you to UH Law's CLE, The End of Chevron Doctrine, the Effect on the Administrative State. So many of you may not know me, but I have been Dean for 10 years and am now the longest serving law dean in the state of Texas. And as part of Dean's prerogative, I want to briefly talk about the Law Center. So we are an excellent law school with students with excellent entering credentials of a median GPA of 3.75, the highest in the law school's history, and a median LSAT of 161, which is almost 80th percentile. And we have several specialty programs in the top 50, including health law, intellectual property, part-time program, all in the top 10, trial advocacy, legal writing, and environmental law in the top 30. We have very talented faculty who publish in top 30 law reviews, and about 20 are members of the American Law Institute. So this is a series of continuing legal education formats, programs, focusing on the pivotal U.S. Supreme Court decisions from the 2023-2024 term. Today's broadcast is segment 2. The goal is to provide meaningful insights into the recent Supreme Court opinions. Over the past 2 years, the U.S. Supreme Court has seen justices weigh in on major decisions that impact our society. The importance of providing knowledge about these important cases cannot be overstated, as the CLEs are part of a broader effort to engage the community in legal issues. Through the CLE, the law faculty provides accurate information and understanding of these landmark cases, and viewers gain knowledge of how these decisions affect law, society, and our lives. An educational institution is a forum for providing this kind of important information by providing light, not heat, on these issues. Kicking off kicking off today's part of the series, this session will cover the impact of the recent decisions on the administrative state. So many may remember Franklin Delano Roosevelt was president after or during the Great Depression, and he created, and through legislation and through presidential enactment, many different agencies and government agencies. And basically it was a start of the administrative state that we see today. And mostly through enactment of Congress, most of them were enactment of Congress, to help regulate a special part of our economy, like federal communications or health, FDA, Federal Drug Administration, but also to take care of a particular practice or area, the technical practice that the Congress was not in a position of having either the expertise or the time to craft and enact legislation. The agencies regulate industries or practices that require close oversight or specialized expertise, which Congress may not have. A perfect example, as I mentioned, the Food and Drug Administration, which decides when drugs come to market. Having these decisions made by an administrative agency with input from medical and pharmaceutical experts, some would say, ensures that decision-making would be made with all the facts. Relying on Congress, in turn, is a challenge because they don't necessarily know the technical issues, and they're not necessarily experts, and the decision might be wrapped up in politics, not in facts. So the case we're going to be looking at today are Loper Bright and Relentless, a case that overturned the Chevron Doctrine. And Professor Andrew Michaels will do a case discussion, and Professor Darren Bush will discuss its impact. And the second case we're going to look at is the case called Jarkesy, which is a case that upended administrative judicial decision-making. Professor Gina Warren will discuss the case, and Professor Tracy Hester will discuss its impact. And then all of us will come back at the end to answer your questions. So you should do the questions in the discussion, in the Q&A during the discussion, during each professor's conversation. And it'll be a panel of our experts moderated by me, the dean. So our experts are here to shed light, not heat, on these important issues. So I first want to we're going to introduce each of the panelists, one for each part that they're going to be talking about. So all the panelists won't be introduced at first. They'll be introduced as we discuss the issue they're talking about. So the first panelist is Andrew Michaels, who's going to talk about Loper Bright. He's going to discuss the case and what the case holds. Professor Michaels teaches in the areas of intellectual property and statutory regulation. And his scholarship has focused in the areas of intellectual property law, jurisprudence, and emergent technologies, including blockchain and artificial intelligence. Professor Michaels received his JD from the NYU Law School and subsequently clerked for Judge Pauline Newman at the U.S. Court of Appeals for the Federal Circuit before practicing primarily as a patent litigator. Professor Michaels' work has been quoted by multiple federal courts and has appeared in scholarly journals such as George Mason Law Review, Stanford Journal of Blockchain Law and Policy, and the Brooklyn Law Review. And immediately prior to joining the Law Center faculty, Professor Michaels was a visiting associate professor and the Frank H. Marks Intellectual Property Fellow at the George Washington University Law School. That's a mouthful, Professor Michaels. So without further ado, let Professor Michaels start this very important conversation.
Okay, thank you, Dean, for that introduction. So, so I'm just going to talk about basically what happened in the Loper Bright decision, which just came out in June of this year. So, essentially, Chevron was overruled. The Chevron Doctrine of deference was overruled in an opinion by Chief Justice Roberts that was joined by 6 members of the court. So just briefly, Chevron essentially required courts to defer to reasonable or permissible agency interpretations of statutes when those statutes were ambiguous and when Congress had delegated the general authority to that agency to administer the statute. And so in this case, that doctrine was overruled and courts will no longer be granting such deference. So I don't want to spend too much time on the particular facts of Loper Bright, but just briefly, it involved the particular statute at issue was the Magnuson-Stevens Fishery Conservation and Management Act, which authorized an agency, the National Marine Fisheries Service, to approve and promulgate regional fishery management plans. So the agency approved a plan that required fishing vessels to pay the salary of required government-certified observers carried on board the fishing vessels. So, so these observers had always been required to be on some of the fishing vessels, but the change here was that now the agency was requiring the vessels themselves to pay the salary of these government-certified observers. And it wasn't clear whether the statute didn't clearly say either way whether the agency was allowed to do that. As in many cases, that was a minor issue that didn't appear to be clearly addressed in the statute. So the petitioners, which were groups of fishermen, challenged the plan as not authorized by the statute. But both the DC Circuit so there were 2 cases that were consolidated, one in DC Circuit and one in the First Circuit. And both of those circuit courts held that the statute was ambiguous on this point, but that the agency interpretation was reasonable or permissible, and so they deferred under Chevron. So then the Supreme Court granted cert just solely on the question of whether Chevron should be overruled or clarified. So the court did discuss Article 3 and to some extent as background, just the idea that separation of powers and the framers envisioned that really the role of courts is to interpret the laws. Um, but the court did not, and they're supposed to do that independent of influence from the political branches, the legislative and executive branches. But the court did not rest its holding on constitutional law. So I think if Congress decided that it wanted to reinstate the Chevron Doctrine, it could at least try to do that, because at least this opinion does not hold that Chevron, that sort of deference is unconstitutional, although Justice Thomas in his concurrence said that he thought it was, but no one joined that concurrence. Justice Gorsuch also had a concurrence where he implied maybe that he thinks it is too. He probably does, but no one joined that concurrence either. So aside from those two, it's not clear that anyone else necessarily thinks that that if Congress wanted to reinstate Chevron, that would be unconstitutional. So the basis on which the court did hold is that Chevron was inconsistent or is inconsistent with the Administrative Procedure Act, which was from around 40 years, an act that was passed about 40 years before Chevron. So in the 1940s, Chevron was a decision in 1984, 40 years ago. Um, so, um, so yeah, the Administrative Procedure Act, as the dean mentioned in his introduction, around the time of the New Deal, there was a large growth in the administrative state and the administrative agencies. And so the Administrative Procedure Act was to some extent a response to that, sort of setting a framework, basic sort of framework and rules for how courts should go about reviewing the actions of administrative agencies. So particularly at issue here, Section 706 of the APA says that the reviewing court shall decide all relevant questions of law. And that is the main provision that the court says Chevron violates, because by mandating that courts defer to certain agency interpretations of statutes, the court says that the courts then are not for themselves deciding these questions of law. So the APA does say that courts should defer to agencies on facts, and that's the arbitrary and capricious standard of review, as well as the substantial evidence standard of review for factual determinations or policy determinations by agencies. But it does say that the court shall decide all questions of law. And the dissent says, and also, what the courts had been saying as far as why Chevron didn't violate this, because this argument has been raised many times before. And what the court had been saying was that, well, 706 doesn't specify that it has to be a de novo standard of review. But now the court says, well, it does specify a deferential standard review on other sections, like for factual determination. So the court now thinks that implies that it needs to be de novo for legal questions. And so, I mean, Chevron also had been based on this sort of legal realist sort of philosophy that, there may not always be only one correct way to read a statute. A lot of times, a statute just doesn't answer sort of some questions. And the idea that it's really a policy choice how to sort of fill in those gaps in the statute. So it's really more of a policy question than a legal question. But the court here takes a very sort of formalist approach, saying that no, there is a best reading to statutes. So it's a legal question that has one best reading, and in the business of statutory interpretation, if it is not the best, it is not permissible. So no longer do we have a range of permissible interpretations of statutes, and it's up to the agency to choose within that range. Now, no, there is one right answer as to how to read this statute. And Chevron had to some extent been based on the idea that, as I mentioned, that filling in those gaps in the statute was really a policy question, or policy questions that are better suited for the agency who deals with the statute on a day-to-day basis, who is more of an expert in these policy matters. But the court here says no, interpreting a statute is a legal question. It is not policy making. So the court says that the view that interpretation of ambiguous statutory provisions amounts to policy making is especially mistaken, and is a profound misconception of the judicial role. So and so the court says that, we have to answer these questions just by using the traditional tools of statutory construction and not using individual policy preferences. I mean, when Chevron was first passed, it was popular amongst conservatives based on the idea that it took judges out of policy making. It drew a line and said, okay, as long as it's reasonable, we're going to leave those questions of policymaking for the executive branch, for the agency. But the court flips on that now and says, no, it's not policymaking. It is just pure legal statutory construction. So the court does say, however, that sometimes the best interpretation may be that the statute delegates a degree of discretion to the agency. For example, if the statute uses words like appropriate or reasonable that leave the agency with a degree of flexibility, so then it is just the court would respect that delegation even under this decision, and just make sure that the agency is acting within the bounds of that delegation, is acting appropriately or reasonably. So, so that is sort of like a loophole to some extent in this decision. And, I think there is going to be a lot of argument about, when should we read that as a delegation? And how different is that really from what we were doing under Chevron? But the court does paint this as a simplification. We don't have to have the two-step test anymore, which had really become more of a 3 or 4-step test, because first we had to decide whether the agency action was formal enough to qualify for Chevron deference, and that was known as step 0 of Chevron, and that was under the Meade decision. So the court says that all of these refinements had transformed the original two-step into a dizzying breakdance. And Justice Kagan in dissent said that if this is the majority's idea of a dizzying breakdance, then the majority needs to get out more. But yeah, I think it is arguably at least a simplification, although we are going to have those questions as to, okay, when is it a delegation, which are going to present some complications themselves. But the agencies are less free to change positions now after a court has decided the issue. It won't just be saying, okay, that's reasonable, but we leave it with you to decide, whether maybe a future administration wants to change their mind about that. They won't do that anymore, because they'll either say that's the right interpretation of the statute or it's not, and here's the right interpretation of the statute, and then that will be fixed. under stare decisis, although, the court, as in this case, does sometimes overrule cases despite stare decisis, but it will be more fixed now and the agency won't be free to change it. But there is still some degree of weight given to agency interpretations of statutes, and that is under the Skidmore Doctrine, which predated Chevron and is still in place, which it's sometimes called Skidmore deference, but that's maybe a bit of a misnomer. It's really more like Skidmore sort of weight or consideration in that it is still ultimately the court that is making the decision. They're not so much deferring as they are just taking into account the agency's opinion, given their expertise, and but it is ultimately up to the court whether to agree with that or not. So it's more like due respect than deference. But some things that might warrant more weight under Skidmore is where the question at issue implicates the agency's expertise, for one thing, and also whether it has been longstanding and consistent are other main factors that we would consider under Skidmore. So it is a simplification in the sense that now that we don't have to think about, okay, is this something that gets Chevron deference or is it something that gets Skidmore? Basically, any agency interpretation of a statute will be considered under Skidmore. And basically, the court will give it some respect if it finds it persuasive, but is not bound in any way to defer to it. So the court does say that cases that relied on Chevron are still subject to stare decisis for their specific statutory interpretations. So the mere fact that a prior case relied on Chevron is not enough to overrule it. But I mean, it's hard to know how much weight to give this because, if the prior decision just said, well, that agency interpretation is reasonable, then it's hard to see how someone couldn't challenge that and say, okay, but is it the right interpretation? Is it the best interpretation? That case didn't decide that question, and so that is still arguably an open question. Okay, so I think since I'm out of time, I will stop there and let the dean introduce the next speaker.
Thank you, Professor Michaels. Dizzying breakdance. Wow, we'll have to talk about that in the Q&A. Next up is Darren Bush, who's going to talk about the impact of Loper Bright. Darren Bush is the Leonard B. Rosenberg Professor of Law. His scholarship focuses on antitrust and economic regulation. Professor Bush received his PhD in economics and JD from the University of Utah. His PhD fields were industrial organization, history of economic thought, labor economics, and political economy, with his dissertation focusing on creating competition in deregulated electricity markets. While completing his JD, he consulted on issues regarding state regulation of electric utilities, interned at the U.S. Department of Justice Antitrust Division, and taught various economics courses. After receiving his JD, he served as an attorney general honor program trial attorney at the Antitrust Division's Transportation, Energy, and Agricultural section, where his primary focus was on the investigation of mergers and anti-competitive conduct in wholesale and retail energy markets and airlines. He's testified numerous times on antitrust matters before congressional committees and federal commissions. In addition, he's also a fourth-degree black belt in Northern Shaolin, Northern Praying Mantis Kung Fu. So you better watch out for Professor Bush. Welcome, Professor Bush. You're on mute, Professor Bush. You're still on mute, Professor Bush.
All right. Thank you, Dean Mance.
You're welcome.
I thought I had unmuted it, but apparently not. Um, so I was on a panel. I moderated a panel this summer about Loper Bright. And one of the panelists was Linda Jellum, who has to completely rewrite her statutory interpretation and regulation casebook. And one of the things we were talking about is some of the implications of Loper. And at that time I said, I'm not sure the court really thought this out very well. And so I started calling it Loper Not So Bright. And there are a couple of reasons for this. And I can't decide if the court's doing this and thinking about these flaws as sort of really flaws, or whether this was created by design to create the chaos that I think is about to come. So here are my areas of concern. The first one is a textual concern, because all of a sudden, after the APA was passed in 1946, and for the longest period of time, courts interpreted the APA and added some judicial gloss to it. And for the longest time, they did what they wanted that was kind of inconsistent with the language of the APA. And so all of a sudden, we care about the text of the APA. That has some implications. The second thing after Loper Bright was I thought Chevron was already dead. I'll talk about what it means to pretend for the longest period of time, as the court has, that it's not dead, and what the implications are now that it is finally pronounced it dead. My third concern is about Congress and how Congress can fix statutes that the court has determined it's with its own purview to interpret, and if it interprets it wrongly, whether Congress can go about and fix that. There's the stare decisis issue that Professor Michaels pointed out, and whether or not the court actually believes that when it says that there's really no backsies. And then finally, Skidmore as a standard. I put the word sucks in here, but it's an awful standard, and you don't have to take my word for it. You can take that of Justice Scalia. So the APA, text of the APA says lots of things. It says that you shall vacate decisions that are arbitrary and capricious. And Loper Bright says the text of the APA means what it says. Okay, so does that mean that the courts are no longer going to reverse and remand? They're going to merely vacate and remand? This would shock Judge Bork, who in Independent Tankers v. Dole, for example, when he was the most angry at an agency, waited 6 months to contemplate vacating a rule that was in place, because we were concerned, and the courts were concerned, about reliance on agency rules. And by altering that, by potentially altering that the APA means what it says, are we just going to vacate, which means we really can't rely on agency rules until the courts bless them? Another thing that's in the APA and the text that means what it says is the difference between arbitrary and capricious and substantial evidence under 706(2)A of the APA and 706(2)E of the APA. And for the longest period of time, courts have not really declared that those two were different. In State Farm, for example, the hard look case, as we call it, the Supreme Court walks right by the statute that says rules have to be decided on the record after a hearing, which requires substantial evidence review as formal rulemaking, and decides to do arbitrary and capricious analysis. In Dickinson v. Zerko, Breyer says, I don't know what the difference between these things are, but we should probably stick with what the statute says. So I think the court, if it really means that APA means what it says, has to start defining what some of these terms mean. And I'm not sure that's in a position to do that. And I don't think it understands what those words mean in some instances. Another issue is formal adjudication is actually present in the APA, and so I think we ought to take that seriously, because the APA means what it says. But the Supreme Court just had rendered its opinion in Jarkesy, and I don't want to steal anybody's thunder, but formal adjudications in the APA. Are we just going to upend all of that, given that the APA means what it says? And of course, if we're really worried about the APA, we should worry about its purposes of uniformity and transparency. And I question whether or not Loper Bright, brings those to fruition. So Chevron was supposedly alive and well and was held out to the administrative agencies. Hey, look, you get deference. You get to interpret your statutes, and we'll let you do that so long as it's reasonable. But that's not necessarily the case. And since as I mentioned, the last case where the court relied upon Chevron was in 2016. So Chevron's been dead for 8 years. And the court admits this in Loper. It says that was the last time we've actually done this anyway. So we might as well just tell you it's dead now. All right. But even before then, we had some indications that Chevron was merely in name only. And so if it was already dead, the court was certainly playing like it was alive, like that film Weekend at Bernie's. And that's the GIF from Weekend at Bernie's. So, for example, in MCI versus AT&T, the case about long-distance telecom, and Scalia talks in terms of Chevron and says that the agency can't remove tariffs for competitive long-distance carriers because the statute says modify, and it means what it means. And so the agency's interpretation, despite the purposes of the act to create competition, is wrong, right? So Scalia was on step one, Breyer was on step two with respect to purposes of the act. But really, in fact, is that any different under Loper Bright, just saying it doesn't mean that, go away? In the FDA, after the 60 Minutes scandal, where the cigarette companies admitted that they were causing people to get addicted to cigarettes, after the smoking gun, the FDA said, hey, our statute says if it's intended to transform the body, that we have jurisdiction all of a sudden. And O'Connor says, no, you don't. No, you don't. You don't, because you said you didn't in the past. And so you're locked into that. And Congress has passed several laws in which you weren't mentioned to suggest the same. And so your interpretation's wrong. And so Chevron wasn't there either. Some agencies have never gotten Chevron deference. The FTC, the one I work with most often, is the Rodney Dangerfield of agencies. It gets no respect, none. And it has some of that language that Professor Michaels points to in terms of unfair method of competition, right? And that broad language that seems to suggest they ought to. And just recently, the FTC's non-compete rule was had a blanket injunction in what's the state we're in? Texas. Chevron was never binary. Some agencies got a lot of deference, some got none, right? And so it wasn't as if Chevron was actually functional in some sort of standard kind of way. It was very much like Skidmore in the first place. And of course, after Major Questions Doctrine came to be, there wasn't much left of Chevron anyway. So can Congress fix this? Well, can Congress craft a statute to satisfy the court? I don't know. The last time I know that Congress crafted a statute to repair a statute was the Tunney Act, and citing me, I have to throw that in there. But the court just ignored it. Basically ignored the change in the statute and the legislative history saying that you did that interpretation wrong, and here is how we really meant it to happen, and the court just blew it off. So I'm not sure that the Congress can fix Loper. I'm not sure that Congress can fix statutes, and I'm not sure it's inclined to do anything at this point, to do anything apart from tweet and win elections. So what that means is the court has a very great opportunity to do a power grab and be the only ones who are actually kind of running things, because executive branch agencies answer to the court. So I call this a reverse Brand X. Brand X was a case that said basically if there's any interpretations of the statute prior to Chevron, if the statute was already clear, it remains clear. And if it wasn't, if it was ambiguous, then the agency gets another whack at it with Chevron deference. Well, all right. So the court here says stare decisis is in play, but I can't help but wonder if there's going to be some sort of reverse Brand X, because it is never the case that the statute that the stare decisis only relies on Chevron. It relies on some interpretation of the statute. And does that statute, despite the fact it was interpreted under Chevron, is that wrong? And I can't think that the court's going to resist the challenge to interpret those statutes, because who better to interpret statutes according to SCOTUS than SCOTUS? Okay, what is Skidmore? Well, Professor Michaels pointed out it's really not much of anything. It's like the Force. It's this weighting of authority, and it's not uniform. It's not consistent. And therefore, it's a mess. And you don't have to take this is all that Skidmore says about deference. It's in the second to last paragraph of the decision. So Justice Scalia in Meade actually points out the problems of Skidmore and says, how could you possibly, in his dissent, how could you possibly unleash this on anything, right? To condemn a vast body of agency action to this regime, right? And now we're going to include rulemaking, formal and informal, and adjudication as well, right? Is irresponsible, right? And so, Justice Scalia was an admin law professor before he got another gig. And so he was very much concerned about these issues, and I think we ought to be as well. So what's my prediction? Well, pain. I think that stare decisis, I think the court's a little glib there, and a nudge, nudge, wink, wink. And Justice Alito had recently said, please, come everybody, challenge. So I don't believe the stare decisis language of SCOTUS. I also think that there's other threats to the agency. Thomas in Whitman versus American Trucking, which is a 2001 case, and his concurrence says, I don't think that the administrative state is constitutional. And that is surely going to be a constant threat, even in the backdrop of people thinking this is the last that the court's going to deal with these issues. I think Professor Michaels is right that there's going to be ossification of rules, despite all these different threats, and it may be because of them. I think there's going to be inconsistent results. And I think people are going to come out of the woodwork because of the standing that Corner Post is now granted. And that's all I have.
Thank you, Professor Bush. That was very nicely done. And we're now going to talk about the Jarkesy case. And Gina Warren will be up next. Professor Warren is the A.L. O'Quinn Chair in Environmental Studies and co-director of our nationally ranked Environment, Energy, and Natural Resources Center. Prior to joining the Law Center in 2016, she taught at Texas A&M University School of Law, and prior to that at Duquesne University School of Law. At Law Center, she serves as faculty mentor to 1L students, as involved in the Law Center's pipeline program. Professor Warren was voted the Student Bar Association Professor of the Year in 2018 and nominated as faculty graduation speaker by the class of 2020. Her teaching and scholarship focus on the nexus between environment, property, social justice, and energy. Her scholarship has appeared in top 20 law reviews and journals, books, and peer-reviewed articles. She's an internationally recognized scholar with publications in prominent journals such as the Boston University Law Review, the Maryland Law Review, the Missouri Law Review, the Nebraska Law Review, the Idaho Law Review, the University of Cologne Business Law Journal, the Columbia Journal of Environmental Law, and she's also been cited by the Colorado Supreme Court and showcased in the Washington Post. Let's welcome Professor Gina Warren.
All right. Thank you, Dean. Sorry you had to read all of that from everything, but okay, let me share my presentation here. And so this was an honor to be able to speak to you about this. And we're talking about the Jarkesy case, and I did kind of try to check the pronunciation for that, and it appears from Mr. Jarkesy's counsel that that's how his name is pronounced. So this is the Securities and Exchange Commission case versus Jarkesy that was decided, I think, one day before Loper Bright or one day after, so right at the same time. And basically, this case says that the Seventh Amendment right to a jury trial is triggered when the SEC seeks to impose punitive fines for securities fraud. And so let's walk through this and see if we can figure out what the court was saying here and look at some insights. And so first, let's look at the background. So you have, sorry, I just need to get this off my screen. Okay, so you have the defendant here, the respondent, George Jarkesy, who is a very well-known conservative political activist and radio show host, and you can look him up. He has he's a very big conservative activist, but he's also a hedge fund investor and manager. And he started 2 hedge funds and raised somewhere around $30 million from about 100 to 120 investors. And then the co-defendant here is Patriot 28, which was the investment advisor. But what happened in this case is that the SEC got whiff of some allegations of fraud and basically brought a case against him. And the case had to do with fraudulent misrepresentation of investment strategies, lying about the identities of people and brokers. And then one of the key things that was in this case is that there was an allegation that they had inflated artificially the price of the shares from 30 cents to $3.30 a share, which basically resulted in them collecting a lot of management fees as a result. And so these, due to these allegations, the SEC decided to bring a case against Mr. Jarkesy. And so just to think about this case is a lot about, this is a procedural case. And so under the statutory regime for the SEC, after the Dodd-Frank case statute, and then that'll be talked about more by Professor Hester later, but basically the SEC had 2 options under its statutory regime. It could bring a case in front of a district court, Article 3 court, or it could decide to prosecute in-house and have an in-house proceeding in front of an administrative law judge. And so the differences here are important for the court. So if you're in front of a federal court, you have the federal rules of civil procedure, the rules of disclosure, discovery, and all of those formalities, and a jury potentially. And then if you're in front of an administrative law judge, you have more relaxed standards for discovery and disclosure. And so the SEC chose to bring this case in front of the administrative law judge and not in a court. And after a 12-day trial, the administrative law judge found fraud and fined Mr. Jarkesy and his co-defendant $300,000. And so there were other remedies also available. There was that were held. There was a cease and desist. There was a requirement that Patriot 28 have to disgorge its earnings of about $700,000. And then there was a prohibition on him Mr. Jarkesy being able to participate in the securities industry as well. But what really triggered this case is the fine for $300,000 because the court said that that is a punitive fine and not intended to just restore the status quo. Okay, so he lost it before the administrative law judge, and then he appealed to the Fifth Circuit. At the appeal to the Fifth Circuit vacated on several grounds. One of those grounds was the Seventh Amendment right to jury, saying that he was entitled to a jury and he didn't have one. There were other grounds that we'll talk about in a minute as well that might be important for later. But the U.S. Supreme Court then granted cert, and that's what we have now, is a look at this case. And so here's the holding, basically, is that it's 6-3, holding in favor of Jarkesy, and they upheld the Fifth Circuit judgment and affirmed the case and remanded it for further proceedings that were consistent with the opinion. And so what did the opinion say? The opinion looked at two different things, two different issues that the U.S. Supreme Court addressed. The first is whether the Seventh Amendment entitles a defendant to a jury trial when the SEC seeks civil penalties against him for securities fraud. And then the second issue is whether the public rights exception to Article 3 jurisdiction applies. And so we'll look at each of those in turn. I want to note here that the majority did not reach questions of violations of the non-delegation doctrine and the separation of powers that the Fifth Circuit actually did reach and could have implications, especially in the Fifth Circuit jurisdiction. Okay, so first of all, let's look at the Seventh Amendment. So here's your Seventh Amendment, and it says, in suits at common law, where the value in controversy is more than $20, the right of a trial by jury shall be preserved. And so the court looked at whether the Seventh Amendment applied to this administrative hearing and whether Mr. Jarkesy was entitled to a jury based on the Seventh Amendment. And the court said yes. So the court looks at this and it says, first of all, the Seventh Amendment is extended to common law claims, so court-made law, and claims that are legal in nature. And there's an exercise by the court to talk about what it means to be legal in nature. But I can summarize it by saying that they said that the most important consideration as to whether something's legal in nature is what the remedy is. So remember earlier I said that the reason that the court really wanted to take this up was because these were punitive fines that were issued by the SEC. And so the court talks about that this isn't money that then is going to be given back to the victims. This is money that the SEC is taking itself. And so feasibly what the court is saying is that a remedy and a fine that's intended to punish or deter is going to trigger this. And so what it sounds like to me when I look at it is that it wouldn't be triggered necessarily by a restitution charge or by a other form of like an equity. So an injunction, that cease and desist didn't trigger it, those types of things. But so anytime there's a remedy in fines and punish that are intended to deter and punish, that's where you would get a Seventh Amendment triggering. And also, given that the court talks about that the statutory basis for the claims for the SEC is really comes out of common law. So common law is an ancestor to the more narrow federal securities fraud that the SEC is prosecuting. And so once it decides that the Seventh Amendment applies to this case, the next thing they do is look at this public rights exception. This is where, in my opinion, this gets confusing as to when something is a public rights exception and when it's not, and how we should look at this and how it's going to be applied. But let's first by starting to say what the exception is. So the exception is that Congress can create what are considered public rights and assign those to an agency for in-house adjudication. So we have this exception that's coming out. It's from the 1856, and so it's a historic exception that's been applied for allowing agencies to have in-house adjudication, even when there's fines or even when there's something else that is legal in nature that might trigger it. And so this case, this Murray lessee case was an embezzlement of government monies case. They upheld the exception there. They've previously upheld it for interstate and foreign commerce, taxation, immigration, public lands questions, public health, which is the OSHA case I want to talk about in just a moment. And then facilities of post office, pensions, veteran payments. And so there's been these, over the last 1.5 centuries, we've upheld this exception for when it was Congress created this public right. But the court here says no. So we're not going to apply it for this case. This case does not satisfy the public rights exception. And so the next step is trying to figure out why. And it's not clear. So, and in fact, Chief Justice Roberts, in his majority opinion, says, yeah, it's not clear. The court has not definitively explained the distinction between public and private rights, and they don't intend to do so today. So then we're left at trying to figure out the types of cases that they were relying on in making this determination. So there were two, the Grand Financiera case and the toll case, that they really relied on in coming to this determination. Those cases, frankly, kind of seem odd to rely on, but those are two different cases that the courts have said that the exception does not apply. But they are very different types of cases than what we have here. And actually, the case that we have here is really much more akin to the OSHA case that we'll talk about in a little bit, where the court did say that the exception applied. But the Grand Financiera case was a private cause of action for fraud that was brought in combination with a bankruptcy proceeding. And the court said, no, you don't need this exception for that because those can be pulled apart. The fraud is based in common law, and so they're entitled to a jury. The toll case is also a very different type of case. It's a clean water violation case, which the administration actually brought the case in federal court. But the court itself denied the jury trial for various reasons. And so in that case, the court said, you don't get this exception. It needs to be done by a jury trial. So it's a little odd that they rely on these two cases. But when I look at what it looks like, the bottom line of what they're saying is that what really matters is the substance of the suit. So if the suit has common law origins, so fraud, for example, it doesn't really matter where it was brought or who brings it or how it's labeled, whether it's labeled through a statute or whether it's labeled through common law. You basically, if the substance of the suit is a common law origin, then you do not get this public rights exception. But it seems very circular, this conversation, and I think it creates some major concern as to when you would now get the ability to use this public rights exception. But let's quickly, I just want to look at the concurring and dissenting opinions, because you have a concurring opinion by Gorsuch and joined by Thomas that is longer than the majority opinion and really feels like the majority didn't go far enough and wanted them to go further and make some bigger statements about, and especially about the separation of powers, due process, and really make this a bigger decision than what it ended up being. And then you have the dissenting opinion who has similar concerns about the separation of power, but from a very different perspective, and thinking that that this is a very disconcerting trend of magnifying judicial power over the executive and the legislative branches. And then this is where the dissenting opinion points out this Atlas case and talks about how this is really the case that if you really wanted to look at a previous case that we used this exception, this public rights exception, then this is the perfect case. Now it has been whittled away, some of its strength has been whittled away through the years, but I find it interesting. I just wanted to point it out because the majority didn't overrule the Atlas case. It tried to distinguish it And that's what leads to a little bit of confusion, because the court said that in this OSHA case, that the basis of the cause of action was not borrowed from common law. The problem with that, and they said it was about building, it was more akin to building rules and building ordinances. The problem with that is that the case actually dealt with wrongful death and negligence types of actions that obviously are coming out of common law. So it's not clear at all what is going to be considered public law to receive this exception and what is not. But as Justice Sotomayor points out, and she was joined by Justice Kagan and Jackson, that this is disconcerting and it could really impact hundreds of federal statutes and dozens of federal agencies that I know Professor Hester is going to talk more about in a moment. And so the bottom line is this. This is what I think I can say for sure that I know about this case, is that a defendant is going to be entitled to a jury trial when a federal agency prosecutes for a cause of action that's going to be borrowed from common law, like fraud. And they seek a legal remedy, like fines, that are intended to punish and deter. So I think if you don't have something borrowed from common law, or you don't have a legal remedy in a remedy in law, and you have a remedy in equity, then this case would not apply. But everything else, it's kind of up in the air as to what we don't know at this point.
Thank you, Professor Warren. That was excellent, as always. So let me introduce our final panelist, who's going to give us a discussion of Jarkesy and its impact. So our final panelist is Professor Tracy Hester. He teaches environmental law at the University of Houston Law Center. We co-directs with Professor Warren the Law Center's nationally ranked Environmental, Energy, and Natural Resources Law Center. And he also directs the University of Houston Center for Carbon Management and Energy. He's a recognized expert on the innovative application of environmental laws to emerging technologies and unanticipated risks, including climate engineering, deep carbonization, particularly in energy production, nanoscale materials and microplastics, and climate liability. In fall 2019, Professor Hester took the first U.S. law school course on climate intervention law, which focused on emerging climate engineering technologies and legal challenges. Professor Hester was named president-elect of the American College of Environmental Lawyers in 2023 and previously served as a regent from 2018 to 2021. He was also elected as a member of the American Law Institute in 2004 and named the top environmental lawyer in Houston in 2011 by Best Lawyers of America. Let me introduce and welcome Professor Tracy Hester.
Thank you very much, Dean Baines. And I have to say, like Professor Warren, I need to find a way to get a shorter introduction of myself. I'm going to be batting cleanup, which means that I am, first of all, extremely honored that I am with such an august panel. Also, I'm going to not have a PowerPoint today, so you'll be subjected to the same hand waving that my students suffer through in my regular classes. So my mission is to discuss the implications of the Jarkesy decision that Professor Warren just outlined. And I will begin with a confession, which is when I was first asked, my sense was that this was not a big deal, that of the 4 decisions that the U.S. Supreme Court handed down the end of its last term, this was the least of them. Y'all may remember the 4 horsemen, as it were, of administrative law. We had the corner post decision, which essentially extended the period within which challenges can be filed against rules under the Administrative Procedure Act. We had Ohio versus EPA, which expanded the sphere of intervention by the courts for emergency relief, particularly for complex administrative challenges involving rules. Loper Bright, which killed Chevron, and then Jarkesy, which seemed to focus on a narrow question, the right to a jury trial to recover penalties in an SEC fraud action. Frankly, most of the commentary, most of the folks I talked to, were struck with the implication that this was a decision that was fairly circumscribed because, one, you can waive your request for a jury. If the party wants to, they can proceed with an action without a jury. In most instances, most defendants are actually dealing with facts that may lead them to not want to have a jury of their peers looking at them and making a decision. It also involved, frankly, the Dodd-Frank Act, which is, this may be an example of Dodd-Frank exceptionalism. This has been a statute that has always been extraordinarily controversial and the subject of concentrated legal attack, has already yielded decisions involving extensions of doctrines dealing with appropriations law and appointment law. But on deeper reflection, I actually think that of the four, Jarkesy actually is the one that raises the deepest questions. In particular, as opposed to the others, which deal with the scope of the power of the court to take emergency action or in statutory interpretation issues, this case deals with constitutional barriers to congressional ability to allocate power to agencies, particularly with enforcement actions that involve penalty actions, which is a core administrative power. To get there, it uses, as Professor Warren described, a unexpectedly malleable test, essentially determining whether or not there was a Seventh Amendment right to a trial by jury in a federal setting. It's a two-part test. One, does it involve a legal claim, which is not measured by a host of different factors. It really boils down to whether or not it actually historically has been a cause of action and a remedy that had been originally conceived of in the common law courts. This is a deeply historical test. And as a result, the court's majority opinion focuses on, to some extent, the fact that the remedy requested with Jarkesy was punitive, retributive, a deterrent judgment, which it said was quintessentially legal and therefore triggered the Seventh Amendment right. But even if it was a legal right, the second step of the test was, is it a public right? In which case it'd be accepted from this sphere of requirement for Article 3 jury trials. And despite the Atlas Roofing decision, which Professor Warren described, the court basically distinguished it away. We could talk about how it did so in a second, because it has big implications for what Jarkesy will mean down the road. But essentially, what are we left with? Essentially, these public rights are defined historically. The court says that this is an exception to the Seventh Amendment rights. So therefore, it needs to be construed narrowly and only in the clearest of circumstances. So as a result, we're left with a fairly narrow historical list of actions involving tribes or public lands or immigration or taxation or embezzlement of public funds, which was the first case. As a result, it's really deeply anti-novelty. It is designed to only grudgingly look to additional new bases of actions created by statute, which might arguably be a public right. It's essentially a formalistic and historical approach, which really makes it extraordinarily difficult for the congressional power to extend and expand the scope of administrative actions. So given this framework, given what the court has handed us, what are the implications? So implication number one is this is not just an SEC case. In particular, there's some discussion in commentary on this decision and also in the decision itself that this is viewed as a sort of narrow issue involving one statute and one type of power. And that's not true. There's actually a host of different statutes that essentially invest power in agencies to either choose which form they want to pursue, be it a court or a straight up direct administrative action for penalties. And some of them even actually don't even give the agency the option of going to court, but mandate that they're going to have to use the administrative enforcement tool. So already this historical approach I've described is running head on to this diversity of different statutory approaches of different agencies. The dissent by Justice Sotomayor points out that we have over 24 agencies already involved in this kind of situation, with over 200 statutes that raise some of these issues. Now, that's just the statutes. In addition, we have an enormous variety of the types of administrative actions and remedies, and those are going to not fit easily into this box that the Supreme Court has created to fit into a historical precedent for a public right. Atlas roofing is probably one of the best examples. The court, as Professor Warren pointed out, looked to Atlas roofing and essentially said that it dealt with a public right mainly because it wasn't essentially a legal issue. The type of the nature of claim involved was not a traditional common law action, but instead was a highly complex and technically driven safety standard, which the court analogized to a building code. Well, that creates a bit of a problem. One, as Professor pointed out, in Atlas roofing, it actually was a case involving the death of employees on the work site, which almost prima facie would be analogous to a negligence claim, which would be a classic common law action. In addition, as well, there's a lot of other agency actions which are going to fit on both sides of that divide that the court tried to distinguish with Atlas roofing. The world I live in is environmental law. And so imagine, if you will, the Environmental Protection Agency. Under most of the statutes of the Environmental Protection Agency, the agency has a choice to enforce the requirements, but it can typically be characterized as either an attempt to impose obligations under very complex, technically driven permits have numerical parameters with deep technical roots. In other words, something that sounds like the building code analogy of Atlas roofing. Or alternatively, there's straight up common law analogs to nuisance actions. It fits on both sides. And so as a result, this test we have is really going to create probably greater confusion. That's just the simplest possible example. We're also looking at a host of other types of administrative tools that the court is going to be immediately tasked with trying to sort out. To give it just a short list again, restitution orders, which are not punitive or deterrent, but simply restore the status quo. Disgorgement of illegally obtained profits. That again can be restoring status quo, a typical equitable remedy, and not a legal remedy that would trigger jury obligations. In environmental law, particularly, for example, under the Superfund statute, EPA has the ability to invoke administrative orders by statute called Section 106 orders, which basically order particular types of parties to do a cleanup. And if they fail to do so, they are subject to treble damages, the cost of the cleanup, plus a daily penalty. Which side of the line does that fit into? Is that going to be a punitive legal remedy, or is that an equitable remedy, or is it a blend? The answer is almost certainly the latter. But if that's the case, how do you determine which side of the Seventh Amendment jury right does it trigger? Do you have to separate the action and have one handled in one form and one in the other? This doesn't even get into other things such as particular statutory liens or supplemental environmental projects, which are actually voluntary settlements, but which impose effectively penalties, but in a way that doesn't necessarily trigger Seventh Amendment rights. So obviously much confusion ahead. I think Professor Ward had it nailed exactly. We have just one clear item from the decision, but all other possible permutations and a vast host of other agencies were prepared for probably much litigation ahead. That's at the surface. A couple of parting thoughts. The deeper question that this decision involves is enforcement of statutory obligations by non-Article 3 entities. In other words, entities beyond Article 3 courts. As you all know in this line, that there are a host of different entities that are created under Article 1 and are not Article 3 courts that nonetheless impose penalties or have other types of financial sanctions. These include everything from the bankruptcy court, which the Supreme Court's opinion in Jarkesy addresses. It includes immigration courts. It includes military courts. It includes the trial division of the claims court. There's an array of different judicial bodies that look a lot like courts, but are not Article 3 courts. The scope of an Article 7 right to a jury trial is going to be, I think, put into play to some extent, given the scope of this decision and its deep historical roots. In addition, beyond Article 3 courts, it's not just Article 1 federal courts, we also may have state courts, and they in turn often hear federal law-based claims. This is particularly important in environmental law because most federal environmental programs are delegated to states for enforcement, which means that you are outright enforcing a federal program obligation in a state court, either directly with federal law or through a state law which has to meet federal standards. How is this template going to fit with Jarkesy? Again, the court doesn't address that. So with that in mind, what's the playbook going ahead? Just essentially, one, imagine which party you are. If you're the government, if you're an agency, the playbook after Jarkesy and the other four opinions, the other three opinions for the four horsemen. Well, the government, one, is going to be under pressure to choose certain remedies with the form in mind. If they wish to not trigger a jury obligation, we're going to see a much greater emphasis on equitable judicial proceedings and injunction actions to compel either immediate action by a party that may trigger financial consequences but not call it a penalty, or alternatively, we're going to see injunctions that will essentially freeze the status quo and compel action by the defendants. In addition as well, we're going to see more orders being issued that are going to be couched in equitable terms that don't involve an actual payment, but may involve disgorgement, that may involve other types of actions that could be couched as equitable relief if they were brought into court. The agencies are going to have to go back and redraft the way that they approach the calculation of penalties. Most penalty policies all use the same model. The model is we have two parts to a penalty. One is a gravity-based penalty. The other is a recovery of economic benefit. Well, the problem is the gravity-based penalty piece is specifically predicated on the moral gravity of the action in the violation and the need to deter future occurrences of it. So it is almost as if it was written to trigger concerns under the Jarkesy decision, as opposed to the recovery of the economic benefit, which oftentimes is larger than a gravity-based penalty and is strictly a restoration of the status quo and disgorgement of illegally gained profit. So it's not beyond contemplation that the agencies are going to have to go back and rethink the way they calculate penalties if they want to avoid having to have a jury trial on every penalty action. And then last, of course, the agencies are going to need to look at the statutes and maybe go back to Congress and see if there's a way to redraft them to address these issues. But that's going to open a whole nother can of worms. That's the government. The other parties, of course, would be the regulated community. And I suspect here we're going to see a use of all four of the four horsemen holistically, a systematic inventory of statutes that might be triggered by them. You may see attempts to create special purpose entities that would use the corner post extension of the time period to challenge. More attempts for emergency relief. But the key thing here is that for Jarkesy, it's the constitutional wedge. It can piggyback on these congressional efforts that we're seeing already to try and highlight instances of agency, quote, abuse. So with that in mind, a final thought, and this one is more geared towards watch what's coming at you from a different angle. We've only talked about the Supreme Court decision. Don't forget the Fifth Circuit decision is still on the books. The Supreme Court essentially did not reach an opinion on the other two bases for the opinion that the Fifth Circuit issued. The Fifth Circuit said that there was a right to a jury trial and that was a basis for reversing the opinion of the penalty action. But it also held that there was a non-delegation challenge where Congress had improperly given the SEC the legislative power to choose which forum it was going to prosecute in. That non-delegation challenge, which is a very deep-rooted challenge to the very notion of administrative administration, is not disturbed by the Supreme Court opinion and is still good law in the Fifth Circuit. The Fifth Circuit also held for its third ground that the SEC was improperly constituted because it had overly extensive protection of the administrators so that they could not be removed at will by the executive. So put those three together, the Fifth Circuit is essentially an island because no other circuit has held this type of administrative challenge on constitutional grounds. We are going to navigate non-delegation challenges and appointment challenges that the rest of the nation is not yet having to reconcile. I predict we're going to end up pretty quickly with a circuit split, and that the Supreme Court is going to have to wrestle with the other two issues pretty quickly. In the meantime, until they do, we're going to see agencies recitate what's called the non-acquiescence doctrine, where essentially they're going to say that the circuit court may interpret the law in this particular way. We're not going to use that interpretation or honor it outside of that circuit, so that the agency will have different interpretations of the same statute in different parts of the country as a form of not acquiescing to the circuit court's opinion. It's a highly controversial doctrine. Attempts to put it into regulations have been also very controversial, but I would not be surprised if it came back. But for now, the Fifth Circuit is essentially a test lab for crafting the post-administrative state. And it should be interesting to see what happens with this. So stay tuned. Jarkesy is the first of many other challenges to come. And with that, I'll turn the mic back to the Dean for the Q&A.
Thank you, Professor Hester. And I welcome back all our panelists to have a roundtable conversation where we discuss some questions facilitated by me, but also to answer some of your questions in the Q&A. So Professor Warren, there you go. Great, thank you. So, it's really interesting when we look at this series of cases and we look at some of the other ones that, and this one specifically looks at the administrative state and the state of regulation. So I know all of you have talked a little bit about this, but how do we deal with, and how does these cases deal with regulation generally in administrative state? What effect does it have on that? So if you're a regulator, if you're working for the EPA or the FCC or someone, what do you do in the context of this? And what effect do you think it might have on regulation and the administrative state? Any takers? See Professor Bush.
Look, I live in the realm of antitrust law, and so we're very comfortable with the uncertainty of what courts might do all the time, and that is probably precisely what the court is kind of gunning for. You recall that Chevron arose as a deferential standard to deregulation, to the elimination of regulations, to sort of support the neoliberal agenda of the time. So it's not surprising that the court would sort of recoil now to sort of halt regulations for health, safety, welfare, or whatnot. And so if the approach of what to do if a rule is promulgated is probably a wait and see approach. It won't take more than a second for stakeholders to challenge a rule. Look at what happened with the FTC non-compete. They didn't even have standing yet. They didn't even have a final rule. And their rule was challenged. So I think you're going to see a lot more of that, and it's going to cause a little bit of a pause and delay before you start having to think about implementing rules.
Anybody else? Professor Warren, looks like are you? No?
I mean, one thing that comes to mind for me is as a litigator. So as someone who used to do some of the work with FERC and state regulations, regulatory bodies, one thing that comes to mind is whether you want this from the Jarkesy case. So a lot of firms might not want to actually be in front of a jury when they're bringing these types of fraud cases. It could come out much worse in many occasions. And so I did a little bit of research about, in the Jarkesy case, they said that there was this alleged bias that the SEC won like 90% of contested in-house proceedings versus 69 of out of court. But then when I did a little more research, that was an allegation that was made by the Wall Street Journal. And actually there's a professor who's now at Georgetown, professor, and I'm gonna mess this up, Velikonja, who did a study, an empirical study that suggested that that's not the case. So when you really think about, controlling for dispositive motions, controlling for summary judgments, controlling for settlements, controlling for all kinds of things, it's not necessarily the case that it's going to be better for a client to be in a court with a jury. And so one thing that I think you might see more of is what like FERC has in the Federal Power Act, right? It has you get to choose. So if you're a defendant, you get to choose. Do I want to be in the administrative court, or do I want to be in the district court? So I think some of it could be just be careful what you wish for, because if you're in front of a jury in some locations, you might get a bigger fine than a $300,000 fine.
Good point. Mr. Hester, I see you shaking your head.
Always a dangerous tactic that always guarantees the student gets called on in class. I'll just simply say, I agree with Professor Warren. I might add that it's not the end of the administrative state. This arm wrestling is going to continue. What I expect is going to happen is a lot of the disputes that were in Chevron terms are going to be transmuted over to Skidmore terms. We're going to see a lot more fights over whether something is a delegation of discretion to the agency, which if you go back and read the original Chevron opinion, Justice Stevens was very clear that if Congress explicitly gives discretion to the agency, the courts have to review it with an arbitrary and capricious standard, even if it's a legal interpretation. So, this court seems comfortable with that as long as it's a clear, it's a discretion that's given to the agency by the statute, and it's not a deference that's obligated that the court has to give just because of ambiguous language. The other thing is, I suspect we're going to end up with a lot of attempts to reopen precedent despite the court's side. I have to agree with Professor Bush. It's stare decisis is not a magic sauce that the court can decide to apply or not apply by choice. It's driven by internal concerns and deliberations and institutional needs. And I suspect a lot of folks are going to look to reopen Chevron Step 2 precedents, and they're going to use Skidmore to do it. And that's going to create a lot of uncertainty in the near future.
Mr. Michaels, any thoughts?
Yeah, I mean, I think that agencies will probably feel more constrained by the statute in light of the Loper Bright decision. So if they were considering doing something that was maybe like arguably within their authority, but maybe sort of on the edge of it, maybe they thought it was a reasonable interpretation, but maybe not the best interpretation, and maybe now they won't try to do something like that.
It's also interesting that the court seems to be going slower. It's making major change, but it's not going to the degree that some justices want to go to at this point. It's sort of interesting strategy, because in other areas they've made abrupt changes and upturned everything. Here it seems as though it's a little bit slower than it could be. Because they've not really, as you all indicated, they have not totally taken a declarative position on some of these issues. Any thoughts? Yes, President Bush.
You don't have to. You don't have to reach non-delegation yet if you have the ability to halt the agency's actions. And you don't have to use major questions doctrine anymore, because in fact, you've made everything a major question. You don't have to worry as much about agency enforcement because, because of you've kind of pushed back on the adjudicatory powers of the agency. I think these things, and then you don't have to do those extra steps because you've opened up the can of worms with a threat that anyone anywhere has standing to challenge a rule no matter when. So yeah, I think there's still that threat of non-delegation of those other challenges, but that's just a threat for now because we have all these other things to cause the agencies to pause.
Any other thoughts? So what we could look at is that I think several of you mentioned the fact that it's almost like the courts have taken this power, right? It's like it has taken this power and has aggrandized itself, I guess, from the standpoint of the legislature or the regulatory agencies. But is the court the right place to determine what kind of drug should come to the market and when it should come to the market? Is the court the right place to make decisions on, telecommunications issues, electric regulation? Is the court the right place to think about, flying and transportation issues? Is the court the right place for that to happen? And is that where it would happen, right? Because the agency may not necessarily have the authority anymore to make, or to certainly be deferred to them. It's either Congress has to pass an act, as Professor Bush said, well, they haven't really passed very much of anything lately. And if Congress doesn't do anything, then what happens, right? What's the effect on society, I guess, to some degree? If the regulators feel like they can't do anything, as some of you mentioned, Congress hasn't done anything, and then what impact does it have on stuff that may be very important to us? Like the latest breakthrough in drugs, for instance. I see Professor Hester shaking his head, which is, as you said, a bad thing.
Gotta stop doing that. I'll agree, but of course I'll muddy it as well. I don't think courts are going to be in the business of deciding complex technical issues of flight certifications or drug approvals, although that's certainly a specter we have to worry about. Those are typically going to be fact-driven, actual approval decisions that are going to be still subject to ultimately an arbitrary and capricious test. This whole fight is over really the narrow subset of statutory interpretation. So if I'm an agency, I'm going to do my darndest to make sure that I've cabined off as much as possible what's considered to be a mixed fact legal question and what's going to be a purely statutory question and signal it in the record. I'd also be curious if we're going to see agencies stop doing the tactic that worked in the past, but apparently is not anymore, which is papering the record to death, trying to build a reason why a court has to defer because they've made a reasonable decision just from the length of the record and the responses to all the comments. I mean, that's just not proving to be a winning game to make it worth the effort. So be curious. We might see some effort to perhaps streamline it, just get to court, do it more quickly. I wish that they could, certify a question for an opinion from the court, but unfortunately that's not allowed by the Article 3. But I think they're going to try and do something different because this has gotten to be a self-defeating process.
I see Professor Warren and Professor Bush sort of indicating they want to get in, it seems to me.
Yeah, I should have saved what I said earlier here, right? So I think it's going to make litigation very expensive. So I think that when you can't defer to the agency, you're going to need more experts. You're going to have more arguments in front of the court. I think you'll need more attorneys, more money to be able to do this. And so I think it will increase litigation, and especially in the short term to figure out even what some of these cases really mean. And then if we don't have as much deference, then I think we'll have many more experts involved to help the courts in their decision making.
Mr. Bush.
And that brings up the fact that antitrust is very comfortable with these problems. You require economic experts, and of course the agencies are hamstrung because they have a very limited budget compared to some of the large, powerful corporations who can afford multiple experts, some of which bill $1,000, $2,000 an hour. And the agencies are a bit hamstrung on the budget. Even with that, there's always threats to the agency budget if it from Congress, members of Congress, if they use their budget for purposes of rules that members of Congress don't like. So yeah, I think it's going to be much more expensive for who? The agency. And I think that they're going to start off with a major deficit, both in terms of financial resources, expertise. We used to think of the agencies having expertise, and the court has said, no, that's not necessarily the case. Well, experts tend to cost money. And so, yeah, I think that this is really limiting on the agencies, and we're going to see a lot more litigation, and it will be expensive for the agency.
Mr. Michaels.
Yeah, I mean, so to your question, yeah, I mean, I think the Loper Bright majority's point that this is really all just pure legal analysis and not at all policy is certainly questionable. And Justice Kagan does question it quite a bit in her dissent and gives a lot of examples. For example, there's a statute that directs an agency to achieve substantial restoration of the Grand Canyon's natural quiet. And so is implementing that really, a legal question, deciding, exactly how many flights are allowed in what places and at what times. Those are really more policy questions. So, her point is that, yeah, we would rather have agencies making those decisions. Although I think, maybe you could still say that, well, that's a delegation to the agency in the words substantial is like those words reasonable or appropriate. So I think that's kind of, as I said, kind of maybe a loophole in the Loper Bright decision, and there will be a lot of argument about that.
Thank you. The other thing is that I was reading a Slate article a few weeks ago that talked about Loper Bright in conjunction with Corner Post versus Board of Governors of Federal Reserve System. And the article said that the federal statute setting a 6-year deadline for lawsuits against the court, set 6-year deadline for statutes against government allowed the company to challenge a federal regulation long after the government allowed a company to challenge that federal regulation. Now, this can happen when a newly incorporated company suffered injury years after the regulation was issued and the statute statute of limitation expired. Do you accept this reasoning? Do you think that is really a possibility that regulations that happened many, many years ago, decades ago, that if I form a new company that is now harmed by it, it can be exempt from the statute of limitations? Is that a reasonable interpretation of these cases? Because that really opens up the door to a lot of things, which I think some of you had alluded to before. Professor Bush.
All right. No one was chomping at the bit, but so I mean, there's still certain hurdles you have to meet. You actually do have to be injured. You have to have standing, and so that's the first problem. But beyond that, yeah, I think that's pretty accurate. And it's not hard to start a corporation. I could do one right now as we're speaking. So there is great concern, and I don't know why it was necessary to open this can of worms. Apart from maybe sending a signal to the administrative agencies, be careful when you promulgate rules. And by the way, if I challenge a rule upon which another rule or interpretation is based, I kind of wonder if there's, if plaintiffs will find a certain thread they can pull and be able to undo multiple rules at once or multiple interpretations of rules at once.
Well, I have to jump on that one if I could. Starting with Professor Bush's last point, absolutely. There are certain foundational rules, and again, in my universe, environmental law, where if you overturn laws, regulations that deal with jurisdictional issues, such as what is the water of the United States, or what constitutes a affected unit for air permitting purposes, it triggers a cascade effect of multiple other rules that rely on them that suddenly get thrown into doubt. But I would go further, but also not quite as far in two other respects. One is that I agree wholeheartedly. It is easy to create corporations, and they don't have to be done in good faith. The entity in Corner Post was created specifically to challenge the regulation. This was not a mom and pop shop that got created after the rule took effect. It got created out of whole cloth specifically for litigation. It didn't matter. But at the same time as well, Corner Post deals with statute periods to challenge rules under the Administrative Procedure Act. And a lot of federal statutes actually have their own timelines to challenge rules that do preclude future claims if someone doesn't hit the deadline. And a lot of environmental laws particularly do that. So Corner Post is pernicious, it's mischievous, but it's not universal, fortunately.
There's a question in the chat because we have a few minutes, very few minutes, about the impact of this on DACA, the executive order. DACA deals with the deferred, the young people who are in the United States unauthorized, but were brought by their parents. And President Obama had issued those orders during the time he was president to try to make sure that they could stay in the United States. Does any of this have any impact on DACA, do you think? So the regulation, it is a refraining from prosecuting, right? Of removing individuals, but it's an executive order. Do we go here or do we go to major questions, which is also a question in the chat about major questions and how this relates to this situation?
I think the silence is not for lack of interest, but none of us feel expert enough on DACA to have an opinion.
I appreciate that.
At least just guessing, but my sense is that if DACA is a review of executive discretion to be able to choose not to enforce regulations, to the extent that statutes constrain that discretion, absolutely, Loper Bright's right at the heart of that. But I don't know if it's going to be directly going to reopen any particular issue in that decision already.
Yeah. Although I suppose the agency that deals with the immigration, or what they call it ICE now, I guess ICE, has jurors or has administrative law judges, I guess. It is a question of like liberty for people their liberty is being taken away. Does it have to be done? Do you think it might affect the administrative law judges in the immigration agency, Jarkesy?
Well, I can say that, so I don't know enough about this to say anything major, but I can say that immigration was one of those areas of public interest that does continue to be in the public rights exception. So it wasn't disturbed by the Jarkesy case. Okay. So that I can say. But about DACA, I really probably can't speak to that.
Okay, appreciate it. It looks like we're at time. So I want to thank our excellent panelists. I think they demonstrate the power of legal education and the impressive, incredible faculty that we have that are really talented scholars and great speakers and lecturers. Thank you for your participation.